Welcome back to another episode of Tyra Talks Truth, where real issues meet real conversations and nothing is left off the table. Good evening. We're going to take a look at the controversial Interception of Communication Bill, which has been a hot topic over the past few days. So we're going to delve into it, and I'm going to give you the information as always, so that you can form your own opinion and not necessarily jump on to any particular bandwagon which is out there. So let's take a look. Section 5 of the bill specifically prohibits interception unless it is done within the confinements of the Act. What does this mean? If you do not, or if you are not someone who's authorized under this particular piece of legislation to intercept communications, you will be liable on conviction to a fine of $500,000 or 7 years imprisonment or both. What does this tell me, and what it should tell you, is that the government is taking your right to privacy very seriously and is making sure that whoever intercepts your communication, that it is done within the confinement or the parameters of this piece of legislation. Now, subsection 2, that is section 5, subsection 2, clearly sets out when interception is not unlawful. That is, when it is allowed. And it lists 7 particular instances where interception will be deemed to be lawful. 1, where there is a warrant, and we'll get down to that later on. 2, if it is done by an authorized officer, and here an authorized officer in section 2 of the piece of legislation is defined by the Commissioner of Police or the Director General of the Anti-Corruption and Anti-Terrorism Agency. So it must be done by the authorized officer in the interest of national security or for the prevention or detection of an offense which is listed under the first schedule. We'll get to that later. Or for the purpose of safeguarding the economic well-being of the state, or for the purpose of giving effect to the provision of any international mutual assistance agreement. However, where it is done under those circumstances and not a warrant, then the interception or the communication cannot be used against you in criminal proceedings, but it will merely be used for the application or as evidence in support of an application for a warrant. So it still goes back down to the warrant. 3, where there is reasonable belief that the person as being intercepted would have consented. 4, during the course of employment in the provision of telecom services. 5, communication where it's not private communication that is stored and acquired in accordance with any other law. So where communication is already stored, maybe a voice note perhaps. 7, where the interception is by a private telecommunications network and is done by a person who has a right to control the operation or use of network or the express or implied consent of such person. So we see in section 5, there are very limited circumstances where it would be lawful for a person to intercept communications. What is also important is section 6, which basically makes it unlawful for you to possess the device that will be used to intercept such communications unless it is authorized by the COP or Director General of Anti-Corruption and Anti-Terrorism Agency, or if you have a warrant, or if you have a license issued by the minister. And if it is that you don't have any of these things and you still go ahead and intercept communications, you will be guilty of an offense, and once convicted on summary conviction, you will have to pay a fine of up to $250,000 or to imprisonment for 5 years or both. So once again, this shows me that the persons who drafted this piece of legislation are taking breaches of this legislation very seriously, as they should. Now, section 7 is that section which I think is the most important section of all these sections, and that would be the section that speaks to the issuance of a warrant. So at the end of the day, a warrant can only be applied by 2 category of persons. That's the COP, the Commissioner of Police, or the Director General of Anti-Corruption or an Anti-Terrorism Agency. And it can only be applied for the Chief Justice or the judge appointed by the Chief Justice. So it is very limited instances, very limited pool of persons that can apply for this warrant, and a very limited pool of persons who can issue the warrant. That is what is most important to note. Also, Section 7 subsection 2 makes it clear where the Chief Justice or another judge appointed by him cannot, must not, because it uses the word shall, must not, and cannot issue a warrant. It creates what I would call a five-limb threshold. A five-limb threshold or test, which has to be satisfied in order for a judge to say that they were within their rights or they were exercising their discretion appropriately by issuing a warrant. And that is one, judge must be satisfied that the warrant is necessary in the interest of national security or for the prevention or detection of any offense listed in the first schedule, and only where there are reasonable grounds for believing that such an offense has been, is being, or is about to be committed. So, it has to be necessary in the interest of national security or for the prevention or detection of crime. And only those crimes listed under the schedule, under the first schedule, and only where there are reasonable grounds to believe that such crimes are being committed, likely to be committed, or have been committed. Two, the information is likely to assist in investigations concerning the aforementioned. And three, other investigative procedures have not been or are likely to be successful in obtaining the information sought or are too dangerous to adopt in the circumstances or are impracticable because the situation is urgent. Four, it is in the best interest of the administration of justice. And five, the interception is proportionate to what is being sought to be achieved. Let's put in a real life scenario. John Doe. John Doe's a drug dealer, but he's not only a drug dealer, he actually he traffics marijuana. And John Doe's dangerous. He's known that if he's going to be approached, he's likely to. So he's not only a drug dealer, but he's a murderer. He's likely to shoot you, or he's likely to do something to put your life in danger. Or maybe if you were to approach him, he would know exactly who it is that snitched on him, and then that person's life would be in danger. And so, because this is an ongoing thing, and a big drug deal is about to go down tomorrow, so within 24 hours, a big drug deal is about to go down. I would say in those circumstances, once the application for a warrant is made, or even an oral application, because it would be urgent, that would satisfy this section 7 subsection 2. But let's put another scenario on the plate. We have John Doe, who is he's a law-abiding citizen, really and truly, but the other day he might have done 100 on the highway when he know he was only supposed to do 80 or 60, and so he was talking about it on his phone. He told somebody, listen, I brought the speed laws. I frightened like I can get charged. I think, yeah, I definitely broke the speed laws. But you know what? When the police approach me, I tell them, no, I was only doing 40. That would not satisfy this piece of legislation because at any day is a traffic offense and it would not be one of those offenses listed under the schedule. Another example would be if you talking about harming your man, you're a law-abiding citizen, but you're just someone who likes to harm, then obviously this piece of legislation will not apply to you and your communications will still be protected. The police does not care about whether or not you are harming your man. So you have no problem. You have nothing to worry about, right? Now, another section which jumps out to me would be that section which speaks to the application having to be supported by an affidavit. Now, like I said previously, there's only one scenario where the application can be made orally, and that is where it is deemed urgent. But even so, under this piece of legislation, within 72 hours of the warrant being issued, the person, the applicant, the one who's applying for the warrant must still produce the application and the affidavit in support in writing. And when we look at what must be contained in the affidavit, we will see that the name of the authorized officer and the entity on behalf of which the application is being made must be disclosed. The facts or allegations being relied on must be disclosed. Sufficient information for a judge to issue the warrant must be in the affidavit. The period for which the warrant is being requested must be
in the particular um, affidavit, and which grounds are being relied on under the act, which are the grounds that I just touched on previously, must be disclosed, and also whether or not the applicant will be requiring assistance from any other entity, and if so, who that entity is. Now, where the grounds is national security, it is stated that the applicant will have to provide written authorization signed by the minister authorizing the application on that ground. And then, furthermore, it says that if a statement is made in the application or the affidavit, knowing that that statement was false, then you will be guilty of an offense and on liable, and liable on summary conviction to a fine of $200,000 or imprisonment for 2 years, or both. So you cannot tell lies in the affidavit. You will be liable to a big set of money. Now, the duration at Section 9, you see that the duration of warrant is 120 days, or where there's an extension requested, it can be extended to a further period, but that period cannot exceed 120 days. So what Section 9 is telling you is that in any instance, a warrant cannot surpass 240 days, which might seem like a lot to you when speaking, but in reality, and in reality of how slow things move in Barbados, 240 days really is not a long period of time. Now, Section 12 allows for the warrant to be revoked at any time before the expiration of the said warrant by the judge that issued the warrant. And some of the instances where this may be is where the authorized officer fails to submit a progress report, where the judge required the authorized officer to do so under Section 13, or where the warrant is no longer necessary, or where it's the execution of the warrant is not possible, are no longer possible. It can be revoked under Section 12. Section 14 is also very important, and it makes it mandatory for the authorized officer to submit a final report to the judge that issued the said warrant, detailing where the interception device was placed, the number of interceptions that was made, whether any relevant evidence was obtained, whether such evidence will be used in any proceedings or further proceedings, and whether any records of communication have been destroyed in accordance with Section 24, and if not, why they have not been destroyed. And Section 24 basically sets out that communications must be destroyed if it's not going to be used in proceedings or further proceedings, if the warrant was revoked or has expired, or where communications were unrelated to the object of investigation. So, if, for example, back to John Doe, who's the drug dealer, and a big drug deal is going down tomorrow, if they also during the interception heard that he's also harming his wife of 10 years, that particular communication must be destroyed. It cannot be then leaked. Well, I shouldn't say it cannot be leaked, but it should not be sent then to his wife for them to have a divorce. As we know, everything is possible of a leak, which is what makes this piece of legislation dangerous. But we will get down to that a little bit later. Now, there is a duty of confidentiality. There is a duty of confidentiality throughout this piece of legislation, more particularly Section 17 and 28, which basically says that any information obtained must be strictly confidential, of course, unless you're disclosing it to the court or anyone else authorized to obtain such communications. Now, Section 20, very important. It makes the evidence which is obtained during such interceptions admissible in court, which is important because it eliminates the need for crown witnesses. Now, we know in Barbados in particular, there's this culture where persons are very reluctant for whatever reason. Maybe it's fear of discrimination or fear of threat being made towards their life or their safety. They refuse to come forward to be witnesses for the prosecution, which oftentimes makes it very difficult for a prosecutor to solidify conviction. So in this particular bill will eliminate that need, because at the end of the day, evidence can be no greater than when it comes from the horse's mouth. So if it is that during interception, John Doe admits to killing someone, then we would not need any witness who was potentially there to see the murder occur. We will have that particular piece of communication stating that, he went about doing what he went about doing. Now, Section 23, very, very, very important. It protects privileged communication. This means that if you're on the phone with your attorney at law, if you're on the phone with your doctor or any other medical practitioner and you're discussing information that by the nature itself is privileged, it remains privileged. So don't worry if you've just committed a crime and you're on the phone with your attorney seeking advice as to how to go about it, that communication cannot be used against you in the courts of law, because that communication will be privileged, and any good lawyer, if the prosecution tries to admit that evidence, will definitely object to said evidence being admitted, right? Part 25, which is also very important, creates an independent monitoring commission, which is very, very important. Now, Mr. Thorne, the leader of opposition, had a lot to say about this part because he focused on the fact that the minister would be the one who will have the power to nominate or appoint these persons which will make up this particular commission. Now, the Section 25 says it has to be 3 people, a retired judge, a member of civil society, and a person nominated by the minister themselves. And after the debate, the Honorable Prime Minister did say that just to satisfy Mr. Thorne's concerns, they would amend that section to state it would be the president and not the minister who will be able to determine who sits on this particular commission. And also, in this section, the remuneration is determined by the minister. This will also be amended to now reflect that the president will be the one to do such things. Now, Mr. Thorne had a lot to say, almost a 2-hour-long speech, but I think the only thing in there that I could grasp that had any sort of essence was the fact that he's saying that this piece of legislation should be free from any sort of political affiliation, or there should be no political motive or objectives behind this piece of legislation. So what he's saying is that the government really wants to implement this bill because they want to know where your political affiliation lies. Now, to me, this is ridiculous because at the end of the day, there's over 200,000 persons in Barbados that are eligible to vote. And that would mean then that we would need to sit down and listen to over 200,000 pieces of communication. So that's 200,000 people we would need to be monitoring. That doesn't mean there's some people like Patsy that would have over 50 phone calls a day. So if we want to monitor Patsy, we will have to sit down and listen to all 50 of those communications just to find out whether she's a BLP or a DLP supporter. To me, this makes no sense when we can simply just look at the results of the past 2 elections, which clearly show that the majority of Barbadians are in support of the Barbados Labour Party. That's a fact, right? Look at the past by-elections. We saw that Chad Blackman won by a massive landslide. And once again, that would show that the general populace of Barbados, the majority, are in support of the Barbados Labour Party. We do not need an Interception of Communications bill to tell us this. It is like a no-brainer. Anyways, moving on. What is also funny to note is that even though Mr. Thorne had an issue with the minister being the one responsible for the commission, we would note that in our sister countries, namely Trinidad and Tobago and Jamaica, it is in fact the minister who is in charge of these things in those jurisdictions as well. And that would be the minister responsible for national security, and it's only obvious why that would be so. So I don't see what is the big deal if it is that other countries like Jamaica and Trinidad and Tobago also have the minister inserted there. It's not an innovative idea. It clearly existed before. Now, countries other than Jamaica and Trinidad, which we already mentioned, which have a similar piece of legislation which creates a similar objective would be Guyana, St. Lucia, St. Kitts, and Grenada. And also, when we look at the international scale of things, we would note that the United States of America, all those countries which are under the EU, Canada, United Kingdom, Australia, Germany, and Japan, these are all countries that have implemented a similar piece of legislation in order to detect and fight crime. Now, when we look at the advantages and disadvantages of a bill of this type, let's look at the advantages first. So the advantages are that there's crime prevention and detection. It helps identify and stop criminal activities such as terrorism, drug trafficking, cybercrime, and organized crime before they escalate. Now, we know that that is obvious. For example, look at the recent case of Miss Blackman, Shakira Blackman. We saw that in that particular case, the prosecution used WhatsApp messages, which were exchanged between herself and another person, which clearly set out the mens rea, the intention of her going down to the salon that particular day and committing the offense that she committed. Now, had we had this particular piece of legislation back then, and she was a person who was under investigation for murder for whatever reason, perhaps the deceased could have called the police and said, listen, I'm always fighting with this girl, and I feel as though there will come a day where she's going to retaliate. And I've heard on the streets that she plans to kill me. So please help me. And with that information, there's then an investigation lodged against Shakira Blackman. Perhaps then the deceased person would still be alive today, and Shakira Blackman would not have to spend the next maybe 35 years in prison. So 2 lives could have been saved with this particular piece of legislation. Another case study would be the EncroChat case study, not in Barbados, but this was a matter in 2020 where there was a joint investigation by the French and Dutch authorities. And through a similar piece of legislation that they had, they were able to dismantle EncroChat, which was a network used by criminals for encrypted communication, where there were millions of messages which spoke to violent attacks, corruption, attempted murders, and drug trafficking. And because of the tools available to the authorities, they were able then to go ahead and dismantle this network and have real-time access to communication content. They were able then to stop or prevent these particular crimes from happening. Now, another advantage would be the fact that you're able to gather strong evidence which provides concrete proof that can be used in court to secure convictions. Like I said previously, especially here in Barbados, there is this culture of not wanting to come forward to be crown witnesses. So this will eliminate that need and that disadvantage on behalf of the DPP or any other prosecutor to basically be able to secure a conviction. And so reoffending or persons getting away without having to do the time or pay the fine, it will become less so. It also helps to locate suspects and victims in terms of kidnapping or where there's missing persons. It breaks down criminal networks because at the end of the day, we need to think broader than just one person. We have a lot of organized crime, and we see that with the importation of the firearms and the drug trafficking ring. It is bigger than just Barbados. A lot of spokes are in the wheel, and at the end of the day, if we can crack down on these networks, then we'll be able to prevent some of these firearms from coming into Barbados and some of these drugs, especially these very aggressive drugs these days that you will see people freaking out when they take said drug. There's a real-time threat response, so it enables rapid action against imminent dangers such as planned attacks. And obviously, it acts as a deterrent because if you know that you're now being monitored, some persons may decide not to engage in certain activities. Others might just find another way around it, as they've been doing all along, which, as we know, the go-to is to get burners. You change your number every week or so, and you buy the SIM card from the Indians because you don't have to provide any sort of identification when purchasing said SIM card. So we know that this type of communication, the interception of communication, has been a very long time. We heard about it, wiretapping. It's been around for a long time. This is nothing new. But what the government is seeking to do now with this piece of legislation is to legislate it, is to confine it, is to give it parameters where persons who are now authorized to act under this piece of legislation have to follow the rules and the guidelines. They can't just do as they want or do as they please. Before, a police officer during a raid or a search could have come and put something in your home and be listening to your conversations and you don't even know. Now we have exactly who can apply for such a warrant and how the warrant is to be executed, how long it's to be there for, and all these other things that are inside of the bill. Now, the disadvantages, obviously, is privacy invasion. But as we know, any good lawyer knows, and as you as a citizen should know, no single right that you have in the Constitution is absolute. What does that mean? It means, yes, you have a right, but at any day, there's a limit on that right. So, perfect example, freedom of expression. We have a right to express ourselves. By any day, we can't walk around the place saying what we want about people, because that's when you will get sued for defamation. You know, you have a right to freedom of expression, but I can't go and tell somebody I'm going to kill you, because as we know, that is use of threatening words or even an assault. And you can be charged criminally for those things. So those are perfect examples of why rights are not absolute. Even before this interception of communications, we had the right to privacy. But any day we know that police officer can come into your home once they have a warrant and search your belongings. Your privacy there has been infringed, but with cause, right? So this is nothing new. Yes, we have a right to privacy, but that right is not absolute. And that has been from time immemorial. Now, also another disadvantage is abuse of power. Abuse of power. And that is why this section 25 is paramount. It is very important to have a commission that is going to safeguard the rights of citizens, that is going to act as a supervisory body, that is going to make sure that the authorities, the actors on this particular piece of legislation that have been empowered, do not abuse such power. And I think it's also good that that body, that commission, is independent of the persons that are going to be carrying out any sort of warrant or search or interception under this particular piece of legislation. Because, for example, the police, where there's an issue with police not adhering to the Police Act, you can go to the Police Complaints Authority, which is an independent body, but after they do their investigations, have to submit a report to the Commission of Police. So that's basically going back to the same police. So it is good here that this commission is made up of persons who are not affiliated with the judiciary in a sense, because it's a retired judge, so he or she's no longer a judge and therefore no longer answerable to the Chief Justice, and someone independent of the Director General of the Anti-Terrorism and Anti-Corruption Agency. It needs to be someone who will not be afraid of standing on these people's toes, because we're dealing with the rights of citizens, and therefore we have to be very careful that once this power is granted, it will not be taken for granted and abused. Now, some persons may argue that, freedom of expression is being infringed because we'll no longer be able to speak how we want to speak. There's fear of reprimand. But like I said, the only time where your communication can be held against you is if there's a warrant in play and if whatever you're speaking about falls under an offense under the first schedule. Also, we have data security concerns. As we know, once we have data, that data can be leaked, that data can be hacked, and therefore there's data security concerns. But I'm hoping that those things are already in place. and that the communications will be stored in such a way that at the end of the day it will be protected from those types of situations. Now, the Schedule 1, which is the one of the final things that I'm going to touch on, basically sets out particular offenses, and you would note that these offenses are of the highest um, rank here in Barbados, and those would be offenses relating to murder, treason, terrorism, trafficking of persons, kidnapping or abduction, money laundering, anything to do with drugs, which are in contravention of the Drug Abuse Prevention and Control Act. So that's transporting, trafficking, manufacturing, producing, supplying, any of those things, and anything which is in relation to the Firearm Act, Chapter 179 of the Laws of Barbados. So the importation, exportation, transshipment of firearms, manufacturing, dealing of firearms, the illegal possession of firearms, the Prevention of Corruption Act, arson, or any offense where you can be liable on conviction for imprisonment for a term of 10 years or more. And then we have the more broader offense, which is aiding, abetting, or conspiring to commit any of the offenses referred to under sections 1 to 15, which would be those sections that I just mentioned. So, long and short, all in all, this bill seems to me, at least in my opinion, and of course you're free to form your own opinion, to merely legislate what has already existed. I do not wholeheartedly believe that the government is trying to be malicious or trying to find out where your political affiliations lie by the implementation of this bill, because it would really make no sense if they wanted to do that. As we know, it already exists, so why not just approach those persons that already have been doing it and get the information they want? Why bring a piece of legislation which confines or restricts the interception of such communications? And also the whole thing about privacy. Your right to privacy is not absolute. We see it in other instances. This is not the first instance where there's a piece of legislation which infringes on your right to privacy, but it justifiably does so. At the end of the day, there's always a balance that we need to create, and as such, I think this balance is warranted. Join me next week as we discuss another bill.